Let me turn now to the subject of internet and/or satellite radio. And let me first say that I believe the success of internet radio is critical for the overall music ecosystem in terms of providing a viable, meaningful alternative to the piracy that was previously taking place and was extremely rampant. And that's a point I believe cannot be overstated. But I do think that there are a few issues relative to the compensation structure and the business practices that I wanted to explore. So let me start with Pandora and Mr. Harrison. Now, I believe you testified earlier today that one of your business practices is to ensure that artists receive a fair share. Is that correct?
First of all, Congressman Jeffries, thank you for the kind words about our service. What I was speaking about is the value that statutory blanket licenses have, not only for services like Pandora that allow us to license content efficiently, but that the songwriters and recording artists actually participate directly in those royalty streams.
Okay. Now, am I correct that Pandora, however, notwithstanding what you just indicated, currently refuses to pay for the use of pre-1972 recordings under either state or federal law?
We do not pay under Section 114 for the performance of pre-72 sound recordings, which is federal law.
But you're also contesting the rights of recording artists to receive any compensation in state court as well, correct?
We do have pending litigation in the state of New York, and yes, we disagree with the claims that the record labels make in that case.
Okay, now pre-1972 recordings are an important part of your business model, true?
Yes, they are.
So you have, for instance, a 60s oldies channel, is that right?
Yes.
And you've got a Motown channel, correct?
I believe so, yes.
50s rock and roll channel, true?
I believe so.
Golden oldies channel?
You're aging out of my demographic, but I believe that's true.
Okay. A doo-wop channel, I believe, is that right?
I believe so.
A classic soul channel as well, correct?
Yes.
Now, Pandora doesn't pay anything for any of the sound recordings played on any of these 6 channels, true?
If the recordings were made after 1972, that would be correct.
Okay. Before 1972, correct?
Correct.
Okay. So, for instance, Respect, which was recorded by Aretha Franklin in 1965. Every time Respect is played on Pandora, Aretha Franklin doesn't receive a dime, correct?
Well, the Pandora would not pay a performance royalty to the record label. She would be paid if she were a songwriter.
Okay. So, My Girl was recorded by the Temptations, I believe, in 1964. The Temptations don't receive a dime of compensation from Pandora every time this extremely popular song is played, correct?
Again, if you're talking about a payment to the record label, that's correct. If they are songwriters, they would get paid.
Okay. And the same would be true for Soul Man, recorded by Sam Moore in 1967. A Change Is Gonna Come, recorded in 1964 by Sam Cooke. Stop in the Name of Love, recorded in 1965 by the Supremes. I would suggest that the failure to pay recording artists for pre-1972 recordings is not a fair business practice. And in the context of this overall discussion, it's a problem that should be voluntarily resolved, but if it is not voluntarily resolved, Congress should act. Let me turn quickly to Sirius XM, which I believe you also refuse to pay recording artists for pre-1972 recordings. Is that correct?
There's no public performance right, and under the law, there is no amount due to them.
Right, under federal law, but under state law, you're also in litigation, I believe, in California, trying to prevent compensation under California state law, correct?
It's clear from the litigation there's no public performance right under state law either.
And in that California state court proceeding, I believe you stated that granting a pre-1972 public performance right would produce a pure windfall to recording artists without any commensurate benefit to the public. That was in your filing in that California case, correct?
Under the way that the policy is written under copyright law, that statement is true.
And I would just suggest a windfall is defined as an unexpected, unearned, or sudden gain or advantage, and compensating artists for their creativity even if it was recorded prior to 1972. It's not a windfall. It's the American way. I'll yield back.
I thank the gentleman.